A very good afternoon to all of you. I would like to extend a warm welcome to all of you to this Global Judicial Colloquium on the theme Rule of Law and Access to Justice in the Age of Uncertainty. As we all know, 2020 has presented us with an unprecedented crisis of COVID-19. With over 3 million confirmed cases and over 200,000 deaths already, we are faced with one of the largest crises of our times. With the casualties of the pandemic, also arise a new set of issues in the world of law and justice, which need immediate attention. In fact, after the role of healthcare, which is required to respond with utmost urgency, it is our justice system that plays a key role to mitigate issues that could arise as a consequence of this pandemic. As the world enters this period of uncertainty, our justice system will be under considerable strain. In the last few months, governments across the world have already introduced emergency laws in response to the COVID-19 pandemic. Healthcare issues, unemployment, cyber frauds, financial frauds, domestic violence, and many other issues relating to law and justice are already visible and faced by the legal systems across the world. These times not only present us with a different range of demands in justice, but also with a very redefining moment to modernize our courtrooms with the aid of technology to make justice literally more accessible in times of quarantine. Therefore, even though today COVID-19 is suspended crossing international borders for a while, this Global Judicial Colloquium with distinguished judges from Australia, India, United States of America, and Tanzania is a very important platform to cross those geographical borders and come together to understand how we can find our collective consciousness to let the rule of law be protected and the access to justice to be promoted, even in such times of uncertainty. Let me introduce my guest for today. Her Excellency, the Honorable Margaret Beazley, the 39th Governor of New South Wales. She commenced her 5-year term on 2nd May 2019. Prior to her appointment as Governor, Her Excellency enjoyed a long and distinguished law career spanning over 40 years. She was appointed as Queen's Counsel in 1989. In 1993, she was made a judge of the Federal Court of Australia, the first woman to sit exclusively in that court. In 1996, she achieved the distinction of being the first woman appointed to the New South Wales Court of Appeal and subsequently as the first woman to be appointed as its president. She served on a number of occasions as administrator of the government of the state of New South Wales. I have our next speaker, Honorable Ms. Justice Sabrina McKenna, a judge of the Supreme Court of Hawaii. She was appointed to the court on 25th January 2011 by the Governor Neil Abercrombie. The nomination was unanimously confirmed by the Hawaii State in February 2011. Justice McKenna earned her undergraduate degree in Japanese from the University of Hawaii. She earned a JD from the University of Hawaii William Richardson School of Law. McKenna spent her early career in private practice. She also taught as an assistant professor at the University of Hawaii Law School. McKenna was also an associate at Goodsill, Anderson, Quinn and Stifel until 1987, then served as general counsel to Ataka. She later became an assistant professor at the law school, and then on November 13, 1993, she became a state district judge, followed by a judge of the Oahu First Circuit, and in 2011, she was appointed and confirmed to the Hawaii Supreme Court. We have with us Honorable Mr. Justice Arjun Kumar Sikri, a very distinguished judge, former judge of the Supreme Court of India. He was appointed as a judge of the High Court of Delhi in July 1999 and served as acting Chief Justice of Delhi High Court. In 2011, he was elevated to the Chief Justice of Punjab and Haryana High Court. Justice Sikri has had a long and distinguished career. He has traveled across the world of academia as well as practice, and of course, being a very distinguished judge. He has studied all his education has happened in the University of Delhi. Besides that, he was also chosen as one of the 50 most influential persons in intellectual property in the world in the survey conducted by Managing Intellectual Property Association for the year 2007. He has been conferred Doctor of Laws honoris causa by the Dr. Ram Manohar Lohia National Law University, Lucknow in November 2013. We're also very fortunate to have Honorable Justice Dr. Emmanuel Ugira Shabuja. Justice Ugira Shabuja is the current and 4th President of the East African Court of Justice. He was appointed as the judge of the Court of Appeals by the summit of the EAC Heads of State in November 13 and subsequently appointed as the judge president of the EACJ in June 2014. Justice Ugira Shabuja focuses on the role of court to ensure the adherence to law in the interpretation and application of and compliance with the treaty. Previously, Justice Judicial was the Dean of the Law School at the University of Rwanda, member of the Superior Council of Judiciary, member of the Supreme Council of Prosecution, senior lecturer at the National University of Rwanda, member of the team of experts in the East African community on fears, challenges, and concerns towards the East African Political Federation. Lastly, we have Honorable Justice Michael Wilson, who is a judge of the Supreme Court of Hawaii, serving before as a Circuit Court judge of the First Circuit since May 2000. As a Circuit Court judge, he presided over a number of important matters. Justice Wilson is a founding member of the Global Judicial Institute on the Environment. Prior to his appointment as a Circuit Judge, Justice Wilson was the Director of the Department of Land and Natural Resources, Chair of the Board of Land and Natural Resources, Chair of the State Water Commission, and a Trustee of the Kahulawe Island Reserve Commission. He was awarded a lifetime membership in the Western Association of Fish and Wildlife Agencies in 1999. Previously, he was a partner in the law firm of Pave Wilson and Glickstein and Hart and Wolf and Wilson, where he practiced civil and criminal trial and appellate law. Very good morning to all of you. Rather good evening in Australia, good evening in Hawaii, and good morning in Tanzania. Let me begin by saying that we deeply appreciate the opportunity to have this Global Judicial Colloquium with all of you. I would also like to say that we have over 500 people joining us in participating in this colloquium. I invite all of them to bring your questions as we continue this discussion. And after the first 45 minutes, we will take up those questions. And please feel free to write in those questions as we continue this discussion. All right. So let me begin my first question to Justice Margaret Beasley. Justice Beasley, the first question that I have for you is that, this has created a new phenomenon in the world today. Rarely ever before, the entire world is battling a disease of this magnitude. So as lawyers, as judges, how do you think our basic civil rights fare as the various governments are enacting policies that are sometimes needed for the welfare of the greater good? While it is important to follow these rules to flatten the curve, as the scientists say, how do we protect and even strengthen our constitutional rights while we are to some extent being asked to temporarily suspend and even postpone their enforcement in some cases?
Yes, Vice Chancellor, it's an interesting question for Australia for this reason. We have not had a huge outbreak of cases. Our figures, I'm from the state of New South Wales, which is the most populous state in Australia, of about sort of 7.5, 8 million people. We've had just over 3,000 cases. We've had 43 deaths. New South Wales, for reasons which can be explained, account for nearly half of all the cases in Australia. In Australia, we have a little under 7,000 cases. We have just over 90 deaths, 93 deaths. So 43 in my state, 93 in the entire country. So what civil rights of ours have been affected? Our movements have been limited. There have been emergency orders that have been made which restrict us to only going out in two by two. We have the emergency order also says that we can go outside for exercise, we can go outside for essential services, we can go outside, in fact, to travel to work. But none of that is limited in time. So if we wanted to, we could walk all day. We could exercise all day outside, provided you're not doing it with more than one person. Now that is and also you could have one family member visit you. So it was a constraint, but it wasn't a constraint whereby we were in the type of lockdown that we read about overseas. We had another emergency measure which required everybody who came into the country to be isolated in a hotel room, and that was policed. Initially, the isolation was supposed to be in a person's own home if they were an Australian. That changed, and it became anybody who came into the country. That was and that was for a period of 14 days when food was provided to the door of a hotel room. That restriction essentially came in because over 2,000 people were let off a cruise ship, and that was the cause of the major transmission of the disease in New South Wales, very significant transmission. All of our emergency orders that we have enacted are for a period of 6 months. They expire in 6 months' time. So to the extent that it is thought that we are going to have ongoing impingements on our freedom of movement, they will automatically expire. The government, of course, has the option to repeal the order prior to that. But at the same token, it can make an order to go longer if it needs to. So, and because we've been travelling well as a nation, the restrictions loosened very slightly yesterday, Friday, the 1st of May. So you can now have 2 people with children visiting you. So it's still not brilliant. We do have restrictions of movement, but in terms of, as I said, what we read from overseas, it's been quite limited. The other matter of concern for a lot of people is that we've now introduced a tracing app. The government has asked us to voluntarily take that up. At the moment, we only have about 3.5 million people have taken it up. The optimum number to assist in the tracing is about 9 to 10 million. So there is some reluctance over that. There was a very quick take up, 2 to 3 million people. Then it just sort of has crept up slowly. People are worried about privacy. Again, it is an app that is supposed to be taken out of operation in 6 months' time. However, the app, the information is located in the United States. Some people object to that it's not even in our own territory. And people generally are worried about privacy, which I think is why there is this slowness of take up above the initial enthusiasm for it. So I do feel that in terms of impingement on civil rights, yes, there is some, but it's very moderate, and we have self-executing termination of all of those measures.
Thank you very much, Margaret, for that really true reports on the status of this lockdown, or rather some sort of suspension of certain rights. Let me quickly move to our own distinguished judge from India, Honorable Justice Arjun Sikri. It's one thing to implement these measures in a country like Australia with a 25 million population. Imagine a country of a 1.3 plus billion people, and that's India. And just imagine that a lockdown of the kind that has been enforced upon us, and now, as we heard yesterday, this lockdown has been extended for 2 more weeks. So how do you think the entire issue of civil liberties and issues of exercising of our freedoms, how does that play in our country, given the complexity of governance that we have in India?
Yeah, thank you, Dr. Rajkumar, and good morning to all the panelists, as well as good morning and good afternoon to all those who are attending and watching us. I think you have rightly hit the nail by saying that India 1.3 plus billion population, and not only that, we're almost 25 to 30% of the persons living below poverty line. And that too, when the poverty line is the threshold which is decided is much inferior to other international standards. And if we go by international standard, it may be maybe 35-40% population which is at the stage of poverty line. Now, in a situation like this, first of all, I mean, it raises various kinds of issues. First of all, we cannot shy away from the problem which COVID-19 has created. And because of that, the measures which are taken by the government, and it's not that the central government has taken, all the state governments, we are a federal country, all the state governments are also supporting, and many state governments are demanding extension from time to time, that it should be extended. because we don't want, although we started much earlier when we had only a few hundred cases, but today it is more than 30,000. That figure is already reached because of population, etc. Now, there is a problem. It is declared as pandemic, which is not only WHO has declared, Indian government has also accepted that position. The notifications have been passed. We have two enactments. Epidemic Act, of course, it is an Act of 1897, and which the purpose for which it was enacted was totally different. Nobody thought that it would be utilized in today's time after 125 years. But the other act is Disaster Management Act, which was passed in the year 2005, and the notifications, etc., have been issued under this act. And because of that, lockdown situation is there, and some relaxation has now come insofar as economic and industrial activity is concerned. But still, by and large, we remain in this lockdown, which is affecting. If I say the COVID-19 has affected India largely in three directions. Number one, and that is the position maybe all over. It's not only peculiar to India, because this epidemic, or which is pandemic, is same all over. Now, first is lives, because many lives are taken away, deaths are taking place. Second is livelihood, that many persons are rendering jobless because of this, and particularly our daily wage workers who are in construction industry and in some other such like industry, daily wage workers in India are 40 million. So this figure has to be kept in mind. And most of them, their livelihood is snatched away because they were daily workers and there's no work for them today. And the third effect of the COVID is lifestyle. So livelihood and lifestyle. Today, lifestyle is we are in a lockdown situation. There is a social distancing. All of us today also are discussing, even from various jurisdictions, we are confined to our houses. And even when after some time it is relaxed, it is going to have its impact for quite some time. And particularly as of today, we don't even know. And we are all groping in the dark. No vaccination has been found so far. No treatment has been found so far. It is hit and trial. So in a situation like this, when on the one hand, if this lockdown situation is not there and we go back to the normal situation where all economic activities are permitted, social gatherings are permitted, it may lead to a situation where the outbreak of this COVID would be so dangerous and alarming that we will not be able to control. So therefore, on the one hand, these measures which are taken are necessary in the interest of public health. On the other hand, it has its impact in so economic and other impacts, as I said, lifestyle and livelihood. And in a country like India, as I'm coming back to that, what Dr. Rajkumar said, of 1.3 billion, where 4 crores or 40 million people are have lost their jobs straight away who are daily wages. Many companies are, particularly I'm here talking of small scale and medium scale companies, they don't want to pay wages to their or salaries to their employees, even when they are not laid off on the ground that you are not working during this period, we will not. There are some who are cutting the wages, that okay, we will cut by 30% or 40%, etc. Now this has a great impact insofar as the livelihood of persons are concerned. Now, when it comes to, in this context, let us talk of civil rights. Now, it is very interesting. Honorable Margaret said that there are not hardly any types of litigation, etc., and there are very minimal kinds of issues which have come and they have been able to take care of, and they are taking care. Courts are also not in a way functioning in a, and that's the situation everywhere. In normal, there's no normal functioning of the courts. But of course, on video conferencing, the hearings are taking place, but these are now limited to only very, very urgent matters. But
Sir,
irony is,
can I just push you on that a bit, sir?
Yeah.
I am familiar with the fact that our courts have not functioned in the normal way so far, and they are taking up some cases. But given the fact that, let's say, many schools and colleges and universities which have the capacity to entirely function in an online manner, like for example, if you think of our university, nothing has changed. All our courses, 5,000 plus students, all the faculty are teaching courses online. So why can't our courts, particularly the Supreme Court of India, high courts across the country, which has, let's say, resources, what is preventing them from functioning as much as normal it can be with the equipment, with the technology that we have? And we'll come back to it later, but I want to quickly seek your answer.
Okay, no problem. If you want me to concentrate that on first, I will, because I was coming to civil liberties, and what I was saying, that even when the urgent matters are being heard, and irony is that these urgent matters are all COVID related matters. There are maybe because of the reason of judicial activism of the Supreme Court, which it has shown, Supreme Court of India, in last 25, 30 years. So every matter, that is what I was going to give a contrast with Australia, what Margaret said, that every matter of every nature is now landed up in either in the High Court or in the Supreme Court. It is COVID related matter. The workers are not given their salary, matter is filed. By daily wage workers are shunted out, matter is filed. Now, when the lockdown took place, another very significant and unique phenomena which occurred in India, because we normally have the migrant labor which come from neighboring states to major cities. Now, if there's no work, they wanted to go back. Now, how to go back when there's a lockdown situation? They were all stopped, and the question is how to feed them. So all these matters are coming up in the court. The courts are passing the directions to the government. Of course, government is also has started so many schemes under which these workers are fed, or those who are, and we have much population which is homeless and live on streets. So it's a question of feeding them also. So all these kinds of cases are landed up in the courts, and courts are passing directions from time to time. So that is one aspect. I won't go into detail, but yes, the question is a very right question and apt question which is put. And I had written one article on this, which was published in a newspaper about 2-3 weeks ago, and it is on Bar and Bench also on their website. And what I said was that, look, the silver lining, although we are facing also much hardship, etc., but the silver lining of this is that it may bring reforms in the judiciary. Because as rightly pointed out by Dr. Rajkumar, that like medical profession, which is taken care of and it cannot be shut down, rather it becomes more important in today's time. After that is the justice delivery system. And therefore courts also cannot be shut down. Of course, like I say, that it is only important cases, urgent matters, but then there is some relaxation. Delhi High Court has taken lead. Some other High Court have included now many more kinds of matters. But then today it can happen only by video conferencing, when physical presence of the courts, because of lockdown court, the lawyers cannot go to the court and cannot appear, and there has to be social distancing. Unlike courts in Western country like US and Australia, and maybe I don't know what is the position in Tanzania. Here, each court in India is having 40 to 50 matters every day, and there are 20 courts or 30 or 40 courts in a one court complex. You can understand maybe 100,000 people are visiting court complex every day. So whether in a situation, COVID-like situation, we can afford it, we cannot. So therefore, the only way out is that it has to be on video conferencing. This experiment has started, but then there are some hiccups in that.
We will come back on the technology side,
okay,
sir. I would like to get some more perspectives.
Yes.
All right, Sabrina,
because
I want
since
to
you asked that question.
Yes, sir. No, I will come back to it in a
yeah.
minute.
Okay.
Sabrina, we want to move from a 1.3 billion country place to a 1.2 million state of Hawaii. So, one of the things that, COVID has done is that While COVID as a disease does not discriminate people, because extremely important and influential people such as the Prime Minister of the UK and many other people have got the disease, but inherently, do you think that the less privileged are more vulnerable because they live in spaces where social distancing is not a luxury that they can afford, or they do jobs which make them more vulnerable? There are many victims and members of marginalized communities still struggle to earn their livelihood and secure basics of living such as food, water, and healthcare. All of this access becomes difficult. So in that sense, our justice delivery mechanisms objective to achieve a higher level of social justice, is it undermined during this crisis?
I would have to say, I think that's definitely true. When we see what's happening in the United States and in Hawaii, what we see is that, for example, as you probably know, the United States is the country that incarcerates people at much significantly higher rates than any other country. We have overcrowded prisons, and it's a problem now in some federal prisons. COVID is running rampant in some prisons in the continent, federal prisons, as well as, I believe, in New York, some other prisons. So there has been a movement amongst judiciaries, and motions and special petitions have been filed. Justice Wilson and I have been actively involved in some of the petitions here to try to address the issue of the crowded prisons. And the reality is that many United States prisons are releasing prisoners in an attempt to curb the COVID, the potential spread. We have been very fortunate in Hawaii so far. We have a population of 1.42 million, and percentage-wise, per capita-wise, I think compared to New South Wales, ours is probably much higher, but we have the lowest per capita COVID rate in the country. And we have 619 confirmed cases. We have 16 deaths. That is the lowest rate in the United States. So we have been very fortunate. But we are very concerned that, yes, it is the people that are disadvantaged, that do not have, there's a professor of Berkeley, Robert Reich, the professor of public policy, that wrote an article called "The Remotes, the Essentials, the Unpaid, and the Forgotten." And what we are dealing with is, we are fortunate to be a part of the remotes class. We can work remotely. However, it is the essentials. Who are the essentials? The people that are required to work. We're seeing situations like in the mainland United States, where people in meat plants are being forced to go back to work despite COVID spreading within the meat plant. And of course, the forgotten includes the prisoners, and perhaps not actually forgotten, but people in nursing homes. And as we know, in Washington, we had a terrible problem with the spread of COVID amongst nursing homes and the elderly. So yes, it is impacting those without the resources much more than those of us that are the remotes, that get to work remotely. And this is something that we must address. In terms of our courts, we have continued services for many types of cases, but we have intentionally stopped landlord-tenant eviction, residential landlord-tenant eviction cases. In addition, the governor did also order that, but before that, we had already stopped that because we didn't want to be creating additional homeless population in Hawaii. And finally, I just want to just mention that in terms of who the essentials, as a woman, I want to mention, it is in the United States, it is often the women, the female professions, the nurses, the people that are working at the stores, at the grocery stores. Our grocery stores are staying open, and it is, we need to think about how much it's impacting
a large number of healthcare workers, also women. Yeah.
Yes, Yes, so we need to think about that and how it is impacting the women. I will just mention that we in the Hawaii Supreme Court, we're very fortunate that we have had online filing for 10 years now. We have been able to continue our work just as normal. On Tuesday, we will have our first video conference oral argument, which will be live streamed on YouTube.
Amazing. What an extraordinary moment. Well, thank you so much, Sabrina. Let me quickly move to Emmanuel. Emmanuel, of course, you are heading an international court of justice in the sense of Eastern African court of justice. Now, the existing framework of international justice to a large extent depend upon a relative normalcy that prevails in national judicial systems. This is taken as assumption for the effective functioning of an international justice system. Now, being a president of a very unique court in the world, how do you see all of this affecting and impacting the work of your court, and in particular, the ability of international justice delivery mechanisms such as the one that is being pursued at your court?
Thank you very much, Professor Kumar. You have rightly pointed out that we are facing one of the major pandemics in our lifetime, and it has affected this region of the world just as it has affected everywhere else in the world. In terms of the East African Court of Justice, we are faced with a very unique situation where judges come from all the 6 partner states, that's Kenya, Uganda, Tanzania, Rwanda, Burundi, and South Sudan, and yet we have to deliver justice. It so happened that lockdowns or shutdowns took place when judges were in their own jurisdictions. So we had to quickly think of ways of dealing with or delivering justice, allowing more access to justice by use of technology. Thankfully, a few months ago, we had this discussion on how to fully go online, because the budget of courts such as ours depend on funding from partner states. So the funding is drastically reduced every year. And we thought that it's important that we look at other means such as video conferencing to deal with certain essentials of delivery of justice. Since we had started this journey, it was much more easier for us to immediately discuss on how we are going to deal with questions of hearings online. And very soon in May, we'll begin to entertain cases online. Last week, we tested the system with lawyers from all over East Africa, and it's working very well. We do hope that we'll succeed, and we look forward to using this system in order to deliver justice. Already we have cases filed under certificate of urgency, obviously questioning how the East African countries are handling the question of curtailing of freedom, such as freedom of movement. And we need to entertain these cases because we are the apex court of East Africa. So we have tested the systems, and we are ready to go. Thank you very much.
Thank you very much, Emmanuel, for that. And it's an extraordinary challenge indeed. All right, let me come to Mike Wilson. This is Mike Wilson. So we, of course, are hearing from our fellow judges from different parts of the world how their legal systems are battling with this situation. And Sabrina had talked about the vulnerability of people who are facing trials and are indeed interacting with the judicial system. So my question to you is that, one of the things about the rule of law as a principle is that it has to recognize the importance of justice at all times. And so our theoretical understanding of rule of law, do you think should be revisited in the sense that pandemics of the kind that we are facing today should help us evolve a new standard for the rule of law, in the sense that vulnerable population who may even be, let's say, in incarceration or even in the wrong side of law, for example, should they be, the response of the judicial system in relation to protecting their own civil liberties should be fundamentally reimagined during these times when the world is facing this extraordinary crisis? In a way, my question is this a new normal that the legal system and judicial system need to evolve?
Well, thank you, Raj, for asking me that very big question, which I will do my best to answer. And I also want to say aloha, which is what we say in Hawaii, on behalf of my great colleague, Justice McKenna, and our court, and also to my wonderful friends that are part of this. I'm very excited to see Justice Sikri and also Justice Agira Shibuya, and it's a pleasure. Governor Beasley, Justice Beasley, you have so many titles, but I'm a little intimidated, but it's a pleasure to share this conference with you too. Anyways, Raj, you're just the right person to ask that question because you're an avatar of human rights. So if you consider the impact of the pandemic on human rights, you could say that it very likely could accelerate the concept of a rule of law that accomplishes what I think the Global University at Jindal works every day to accomplish, which is justice. We have a well-known American citizen who many of us admire, who once made the statement that the trajectory of human history is an arc that bends towards justice. And that, I think, were the words of Barack Obama. So we'll find out, because what's happening during this pandemic, as Justice Sikri rightfully mentioned, and I know my colleague who's an icon of social justice is very focused on, is that we have a growing number of citizens, maybe there are 40% that live at levels of poverty under World Bank standards in India, but the number of people that live in poverty in Hawaii has just shaped our future. Imagine this statistic. During the Great Depression, the worst economic calamity in the history of the United States, the unemployment in Hawaii was about 13%. In 2 months in Hawaii, we went from the lowest unemployment, a very rich, robust economy, to having 37% unemployment. Now, this is in a state that's part of a country, as Justice McKenna mentioned, that is the most punitive in the world when it comes to incarcerating its own citizens. Hawaii is right up there. We would be within the top 30 countries incarcerating people. If you look at our statistic of incarcerating 350 people per 100,000. India incarcerates 24 per 100,000. So your question about how is the arc of history, the bending of justice going to be affected in the future has a lot to do with individual cultures, of course. But we have a big challenge in the United States and in Hawaii because we have just introduced into the system of justice a group that historically is deprived access. Keep in mind, our country is so wealthy. It's the wealthiest in the world, but 3 individuals possess the same amount of wealth as 160 million Americans. The bottom 50% with their combined wealth are the equivalent of 3 individuals. The disparity of wealth is breathtaking. So when we move forward, it's possible that this trend where we have American citizens that can't afford a lawyer, that's an increasing trend, or citizens that are accused of crimes, the increasing trend of them not having access to justice, not having access to an attorney could change. Why? Because this part of the population is going to become a lot bigger, the underprivileged, the low economic group, and they may well come together and say it's time for a kind of social justice that's different. And if that social justice is going to happen, it will be defined by the men and women that are judges. Those issues are going to be brought to the court. the extent to which justice has to move forward in things like discrimination or false stereotypes that are sometimes imposed, for example, on incarcerated people. The United States, part of the reason we incarcerate so many people is we don't understand who they are. You know, so many of them are nonviolent. So many of them have drug problems. If you move to Norway or India or countries that, or Australia that incarcerates 127 per 100,000, there's much more of a concept that, and I'll conclude, that has been advocated and described by Justice Anthony Kennedy from our Supreme Court. And he talks about the role of judges and the role of lawyers. He says, were we to enter the hidden world of punishment, we should be startled by what we see. Now, keep in mind, at least 50% of the cases that we as judges around the world see are people accused of crimes. It's a criminal law. He says, consider its remarkable scale. The nationwide inmate population today is about 2.1 million people. In the United States, the cost of housing, feeding, and caring for inmate population is $40 billion a year. Our resources are misspent. Our punishments too severe. Our sentences too long. The goal of the American correction system is to degrade and demean the prisoner. So he says, his major point is that the prisoner is still a person. He or she is still part of the family of humankind. And that's what, if you will, Norway, which I had the pleasure to visit and study, does with the citizens that become incarcerated. They're still part of the community. They're not seen as somebody separate. So the pandemic can remind us that we are a global humanity and we have to pay attention to those that are disadvantaged, many of whom are in the criminal justice system. So hopefully with the leadership of a kind of teaching philosophy that Jindal has, there will be a change in the arc of justice in the right direction.
Thank you so much, Mike, for those comments. Let me move to Margaret back again. Margaret, from the tone and the tenor of the judges we heard, clearly the judges are concerned about the future of justice delivery mechanism, both during and post-COVID, but also, and you're in a very vantage point. You were a very distinguished judge and president of the New South Wales Court of Appeal, and now you are serving as the governor of the New South Wales. Now, one of the things that has happened during COVID is that dictatorial governments, authoritarian forms of governments around the world have ended up asserting more power. In some ways, emergency type situations have enabled them to acquire more power, assert their powers, and even create new forms of restrictions on freedoms and civil liberties on the people. Now, being part of a democracy such as Australia, what do you think courts should be doing so that even democracies don't end up in a situation where even within democracies, authoritarian tendencies don't creep in, whereby political patronage and other forms of aggrandizing political power does not undermine the fundamental rights and civil liberties of people? In some ways, what should courts be doing at this time?
Again, a big question. Let me come back to a comment and a phrase, in fact, that you used, Raj. You said you used the phrase justice at all times, and that was really the job, if you want to use it very basically, the job of the courts. And I think when we talk about the rule of law, it's probably good to start with what we mean by it. Now, there are many definitions of the rule of law, and it gets expanded and contracted depending on what your viewpoint might be. I think as we are seeking to discuss it now, we are really discussing it in the context of where does the institution of the court stand at this particular time in a pandemic, which has created a world emergency of a type that we haven't seen for a long time. So that's where I would start from. Let's look at from the institutions, and that's what all our speakers and panelists have been referring to. You used the expression justice at all times. Now, in Australia, We haven't shut down the courts. What we did was turned around very quickly to work out how we can keep the courts going. That was the absolutely primary consideration. And there's, in the Supreme Court Act in New South Wales, in the Federal Court Act, and in the acts, the procedural acts all around the country, there is a requirement on courts to resolve disputes. That's what courts do. Courts resolve disputes according to law, and they do so justly, quickly, and as inexpensively as possible. That's our guiding principle here in New South Wales. When this pandemic hit, and there was huge emphasis by the government on people working from home, bearing in mind that in Australia we have a divided legal system in most states anyway, where barristers are private practitioners, big firms are solicitors are, and solicitors usually work in firms. The solicitors worked out very quickly, and they actually even trialed how to work at home, how to get big, sometimes 600 people working from home. Barristers had to set themselves up to do so. The government responded also very quickly because quite a bit of technology was inadequate, and the government responded quickly to upgrade the technology in the court, so that except for our local court, which is continuing to deal with list matters but not with hearings, all other courts are doing hearings and they're doing appeals. One thing that has been suspended are jury trials, but we do have an option here in New South Wales for accused person and the prosecution and the court in conjunction to have a judge alone trial in a criminal matter. So that can happen as well. So I think that the emphasis has to be, to come back to your question, if in a democracy we're not delivering justice, how might we expect those countries which are more autocratic not to do so? I think as democracies we have to take up that challenge, and we have to deliver justice. And the courts can only do that if they're properly resourced. As I said, there was a while there where our district court and in some instances our Supreme Court were not as well able to continue with cases. That's not to say that there aren't problems in running contested litigation using online means. But it actually means that there then just has to be a management system put in place. I was discussing this matter with the judge the other day. He has a big commercial matter about to run. What do you do with witnesses? Witnesses who are perhaps in their own living room, for example, with a solicitor perhaps in her living room and a barrister likewise in her living room. We just don't know where everybody necessarily is. And this judge said, all right, we have to set up a protocol for this trial. And one of the significant protocols he set up was that witnesses had to be in a separate room on their own for the duration of the giving of evidence. They actually then had to make a statement that that was the case. That was then scanned and sent to the other side and to the court, and it was admitted as an exhibit in the case. And that was to hopefully eliminate, but certainly minimise the possibility of witnesses' evidence being contaminated by coaching, being given a wink at the right or wrong time, as it might turn out. So I think in democracies we really can take this on. I think courts can operate. It is difficult. It is not easy. It is difficult. The skills are different, but they can be done. As I said, we're looking hopefully in Australia at things lasting for somewhere between 3 to 6 months before we can get back to a more normal. I don't know what the position is likely to be if we were doing that for 2 years, for example. I think that would create bigger problems. My own view is, and as I speak to the judges, I suspect that trial work and appeal work will significantly go back inside the court. But there will be a lot which will be done online. There'll be a lot of lists which will be run online, so there won't be a necessity for people to come to the court simply to be told that their matter will be listed on a certain date and the like. So I think there will be changes. I think they will be effective changes in the speedier administration of justice. But I do feel as though things, generally there is a real feel for a wish to be in the courtroom. And can I just add one more factor into this? I think being in a courtroom is important to the administration of justice. It adds a solemnity to the occasion. It makes people really understand that everything that they do, every word that they utter, is a word that is given on oath, for example. And I think the tendency when you're not in that environment to be perhaps a little more relaxed could be a temptation. It just could be a temptation. And
thank you so much, Margaret, for that. So let me come to Justice Sikri. Justice Sikri, one of the things that has happened in this new phenomenon is that clearly our own courts have begun to use technology. Remote hearings have become more common. And there have been instances of successful completion of remote court hearings as well. What are your views on, in some ways, e-based adjudication and technology-based dispute resolution? Can this be a phenomenon that we can see even beyond COVID? Can this be a part of a judicial reform process that has been waiting for a while and ultimately can help in addressing the larger pendency problem that we have in our country?
Yeah, before that, Professor Rajkumar, I'm tempted to answer that question which you put to Justice Wilson and Justice Bresray about the rule of law and the role of the courts in such a. So, I mean, I'll take very few minutes in explaining that in Indian context because it becomes very relevant, and then I'll come to this technology. And that is a more rather theme of today's discussion about civil liberties. And you see, you are very right. You're very right. In the particularly, I told you some of the problems which COVID has generated, and it includes what Justice Sabrina said in the very beginning. In Indian courts also had passed the, because our jails are also, prisons are overcrowded, and there was a threat in the beginning that this corona may become, I mean, it may be break of corona and more cases. And therefore, general directions were given by the Supreme Court, then individual high courts also, including Delhi High Court, I know, that if a person has spent, particularly he's charged of, he's an under trial or she is an under trial and charged of an offense for which X period is the punishment, and he or she has spent half of that or up to a particular, say, 3 years or 4 years, they should all be, I mean, without any consideration, should all be released on bail pending trial. So that was one way which the Supreme Court thought of, I mean, as far as taking care of the crowds in the prison. That is one aspect. But then the very important aspect is when we talk of civil liberties during this period, and Professor Rajkumar, you rightly said that, look, what happens, yes, those countries where there is a dictatorship or very less, even if the democracy is there, but it is in a limited form, there is a tendency of those who govern to be more dictatorial, in the sense to take more and more strict measures in these times. But even in other democracies, including liberal democracies like US and India and Australia, Canada, etc., there's always a fear. History shows, and as you also said in your note, that during war times what happens, although those are the times which are, I mean, war times, but then sometimes while dealing with those situations, excesses do take place, and those excesses result in the deprivation of civil liberties of the persons. So today, because of COVID, we are now have two kinds of situations. On the one hand, civil rights of individuals. This may be as right to privacy, what was mentioned, which may be collective right also, individual right also, right of free movement, which is there, right to carry on business, and where the lockdown we are not allowed to do business because the government has issued directive that they are not allowed to open the shops, etc., or establishments. Now, all these rights are otherwise guaranteed under our constitution and fundamental rights. Of course, at the same time, there are provisions in the constitution itself that there can be reasonable restrictions, and like religious rights, but then religious rights are subject to public health. So today, public health demands that, okay, the government may say that you won't go out to public religious places, to the temples, to the mosques, to the churches, etc. Now, question that arises in the whole scenario, that is one aspect. But the other aspect in Indian context is where the rights of the laborers, rights of the prisoners. So it is going to change as far as the attitude of the courts is concerned. And a good activist judge should look into all these problems by giving a new dimension to the entire concept of rule of law. That is my personal opinion. And it's not that you are somebody, if he does that, would be spreading on, say, fresh path, etc. No, there is already a lot of material. When we talk of rule of law is in substance. There's a what we call formal aspect of rule of law. That yes, everybody is. It is a law which governs, and everybody is subordinate to law. And howsoever high you may be, the law is above you. So anybody can be governed, but then a dictator, in a dictatorship, any kind of obnoxious law can be passed, and then the people have to obey that, and it's governed by rule of law. That is not what we mean by rule of law. When we talk of the Dicey, how he conceptualized rule of law, and the Lon Fuller, who talked of inner morality of law, which is to be seen, and in that the fundamental values of morality, justice, and human rights, and proper balance between all these has to be maintained. I think all such issues which are arising because of COVID, this is coming to forefront, and therefore the courts have to deal with all these individual issues by applying such principles of rule of law. Fortunately, and I need not go into detail on this, there are many judgments given by the Supreme Court also on such aspects, so of which it can be taken care of. And secondly, as you rightly said, that now that we have two or three kinds of problems which I say. One is, yes, when it is raising the issues of privacy in so many, whether the surveillance of the state, although at the time when you are talking of tackling the COVID, but at the time the people are allowed to enter into the houses of the persons, whether COVID patient is there or not, and can take up it. So privacy issue would arise in a different context, and there may be misuse of that. So long as it is rightly used, no problem. Likewise, issues of freedom of speech are coming. Like in an Indian context, if I may say so, because two or three cases have come. I won't mention those cases, but then the government, all the governments, and I may say that Indian government is also taking all possible steps in all bona fides to tackle the situation. But at the same time, if suppose I feel that the government is lacking in its effort in this sense or that sense, has I right to criticize the government? Have I right that? And if I criticize the government, can I be persecuted for that? Now, such issues, if they arise, and we talk of, in a democracy, a limited government, the concept of limited government, and in a liberal democracy, where all these individual rights are there. And if such rights, therefore, what I feel is the question which you asked, Justice Margaret, also, that here comes the duty of the courts. And duty of the court, one of the fundamental duties of the court is to protect the rule of law and the democracy. So in given situations, yes, more or less when it comes to the lockdown situation is there and all these measures are taken, nobody has even challenged because we know that they are in larger public interest. But when individual cases where the rights, civil rights of individuals are there, how it is to be tackled by the courts, the courts will have to come out and do its job in protecting the rights of the people. There's another interesting in respect of rule of law, I would say, the issue which would arise. On the one hand, they are the rights of the society, rights of or a section of the society. On the other hand, there are individual rights. Balancing of these rights could also become some sort of challenge for the courts. So having said that, now let me come to the question which you asked about the courts functioning with this technology. Now, insofar as India is concerned, for last maybe 15 or almost 20 years, there have been measures which have been taken, and it is a part of judicial reforms that the system should be computerized totally, e-filing, etc., court fee paid in e-form, documents are filed in e-form. And in Delhi, almost 10 years ago, we had even started e-courts, that is paperless courts, where few courts were working as paperless courts. But what I'm trying to say, without going into detail, that the technology was being used. But insofar as video conferencing is concerned, that was not one of the methods which was used in court hearings. Of course, it was used in a very limited manner, particularly in remand cases, where from the jail, the prisoners don't have to come, and then they are given remand of 10 days, 15 days. So they physically come to the court in hundreds every day and then go back. So it was happening. It has been happening on video conferencing. So the judge sitting in the court, and on video conferencing, he would pass those orders. Now, this, as I was saying earlier, COVID has brought a situation where all this can be accelerated, and this is the opportunity for us to use this technology. And in arbitration world, even the evidence, etc., because what happens, I had one hearing. I'm now international judge of the Singapore International Commercial Court. On 1st April, I was sitting in Delhi. One judge was there because there the lockdown started from 6th April. On 1st April, the one judge from Singapore was sitting in the court. One party, which was one of the advocates representing one of the parties, which was from Singapore, was in the court, but the third judge was sitting in London. So we three judges, and the second party was in Malaysia. So we could hold these hearings, and particularly international disputes where there are parties from it is going to be very cost effective. There's so many advantages of that. It is going to be transparent. And in Indian context, it will lead to court management, case management, if I say that this technology, and with written submissions. And in India, the arguments go on for days together on a particular case, unlike in US, where in US Supreme Court gives only 30 minutes. All that can be now followed with this technology. So therefore, my suggestion is that even if COVID situation, I mean, it is no longer there, technology should remain in use by the courts.
Thank you so much, Justice Sikri, for that. Friends, what is happening is we have over 500 people who are attending this session, and we have already received over 250 questions. So I'm going to slowly begin a Q&A session as well. So it's been an extraordinary response because, and one of the things I have realized over the course of this discussion is that judges rarely get to speak in court. And so when you have an opportunity to speak, you are obviously very generous about it. So I'm happy that you are taking this time. So I'm going to ask a question that has come from one of our viewers, Maithili. This is a question to Justice Emmanuel. She's asking that does the international law allow international courts to take suo motu actions against countries who might have either ignored the pandemic situation or have not taken adequate measures to curb it? Now, of course, we don't need to name the country, but the point here, what she's asking is that does the existing framework of international law help us to take cognizance of these type of situations? Justice Emmanuel.
Yes, I'll speak from the international courts that I know. None of the international courts that I know has any suo motu on any matters to do with international law. It's very few courts which have suo motu powers, notably, obviously, the National Green Tribunal of India has suo motu jurisdiction on environmental matters. Sometimes I wish we had that suo motu jurisdiction, but unfortunately we don't have that suo motu jurisdiction. International judges such as us always wait for the cases to be brought before the court, then we can deal with the cases. as the cases come to us. So we deal with the evidence and the facts as they come to us. So I don't think there's any international court that I've come across, at least not the East African Court of Justice, which has Suomoto jurisdiction to deal with those cases.
Thank you. Thank you so much. Sabrina, there's a question that has come from one of the viewers. She's asking about the prudence of courts to take, let's say, drastic decisions during this time when it has to develop a delicate balance. So, for example, the concern that is expressed by this viewer is that you talked about, and Justice Sikri and also Michael talked about the fact that certain prisoners are being released to ensure the vulnerability that may be posed in prisons. So the viewer is asking, do you feel it is the most intelligent decision to risk the security of people against the risk of the spread of COVID-19 in prisons? And what kind of delicate balancing act courts need to do?
So the orders that we have issued were in response to petitions filed by the Office of Public Defender as well as the American Civil Liberties Union joined in. But basically, we issued orders stating that certain categories of inmates should be considered individually, on an individual basis before the presiding judge as to whether those prisoners could be released. We actually didn't do anything that drastic. Pre-trial detainees, felony inmates that are serving probation as a condition of a felony conviction. And we excluded inmates that had been convicted of certain crimes like murder, homicide, sexual assault, domestic violence. In other words, we excluded categories of prisoners that were considered that what society may consider dangerous. Of course, that did not preclude the public defenders or the defense attorney for filing individual motions with respect to those people. But yes, there is a balance that must be drawn. But as Justice Wilson has indicated, the United States, including Hawaii, over incarcerates. And so therefore, there are many people that would never have been incarcerated in your countries that are in our prisons. People with drug offenses, addicts are in prison. That's the reality in the United States. So yes, we do have to draw a balance, but we are requiring an individualized determination of whether a specific person should be released. And it's the judge that knows the person that reviews it to decide whether or not that person should be released.
Well, thank you so much, Sabrina.
Could I just add in there, Raj? Very similar thing has happened in New South Wales.
In India also, yes.
Okay, right. Michael, there is a question from Gurdeep Dung, and Gurdeep is asking, I think, something very uniquely that's happening in the US as well. While on the one hand, there are people who have gauged the situation and are abiding by the orders of the government, there are a substantial number of people on the other hand who are exercising their right to protest and are coming out on the streets to demonstrate against, let's say, social distancing orders. So how can a balance be struck between necessity of restrictions on the ground of public health with the basic rights of citizens to question those in power? And we are seeing these images across several states in the US that people are protesting against social distancing orders. So how do you deal with it as a judge?
Well, I would enjoy discussing that from the point of view of the tradition of judicial decision making in the sense that would be, I think, most straightforward when making a decision that's based on available facts. And what I'm alluding to is the coronavirus issue, much like climate change, the coronavirus issue is very much fact-based, as opposed to, for example, very important issues that come to courts that are more soft. Let's say whether or not women should be treated equally, whether or not privacy interests should be taken into consideration when it comes to certain segments of the community that might be considered as dangerous. This is not a soft type of judicial analysis because there is an enormous amount of expertise in the scientific community that is explaining the phenomenon. So imagine, and this is true in the United States, that you have a dramatic, flamboyant political figure that has a point of view about what should happen in terms of the way that an emergency should be treated. They're entitled to their opinion. But when you get to court and you have a man or a woman who is appointed to make a decision based on the facts, it's somewhat straightforward. I mean, we've seen in the United States what happened in New York and other places. We have a whole pedigree of experts that are academic experts and in the trenches, emergency physicians. So if there's a question whether a group of well-meaning, angry, and emotional people should decide the law against the facts, that's not a hard one, I would submit, for the man or woman that has to make the decision. You have to protect, as Justice Decree said, this overriding priority, which is the health of your community, so that when you are expressing your extreme point of view that might not be factually based, you can be healthy and free. But we do have to be careful about protecting public health based on the facts.
Thank you so much, Mike. Of course, this program is going very well. We have over 250 questions, but obviously we have another 15 minutes only. So I'm selectively picking up questions. Margaret, by the way, we don't know, Mike, who you talked about. You were explaining about a person. We have no idea about who that person is, but we will have.
Oh, Raj, I look forward to your next visit to the United States, and we can talk about this in more detail.
Margaret, the question to you is that Isha Bakshi, one of the viewers, is asking that, to what extent countries can interfere with each other's, let's say, violation of human rights and not following justice at all in times of pandemic. In a way, I want to further extend the question. Are these moments when we need to strengthen international institutions? We are at a situation where we know that the World Health Organization is also come under attack by different countries, but most vociferously by the United States of America. We also have some people talked about to what extent the United Nations should be taking this matter. We've not had an emergency session of any kind to address this. Are we facing a situation where international institutions have significantly weakened and our ability to use law, including international rule of law, is somewhat, let's say, undermined? And so how do we deal with this as lawyers and judges?
That's a tough one. I could get out of it by saying I'm not an international lawyer as such. But look, I suppose my view on this is very much as a citizen who reads and has a background in law, obviously, which helps forms one's view on these things. But my sense is that international institutions were weakening before this particular crisis. And one could hear, for example, many criticisms of the United Nations for having become overly bureaucratic and for, in effect, very close to existing for itself as a bureaucracy without really, and perhaps having lost some of that connection to the real world issues, the real international issues. By international issues, I say those which affect more than one nation and usually a greater number of nations. So I think the organisations had been weakened in any event. And this could well be an opportunity to recalibrate those institutions. We know what the criticisms are of the WHO, for example. They were criticisms which would have been made, the criticisms that are currently being made of it were criticisms which would have been made of it 10 years ago, to the extent that it can be used as a tool of influence.
Thank you.
In true international law sense, where we as international citizens are really looking not only to our own national position, but understand that a nation lives within an international community, this could well be a very good time when that greater good, international good, could well be looked at and these institutions recalibrated. How do you do that? That's itself quite extraordinary. We might remember that the League of Nations fell and was replaced by the United Nations. And so the United Nations has survived for a much longer time. But maybe it's time to look at some of these. Maybe it's time to perhaps make them a little more lean, for example. That could be very, very helpful.
Those are wonderful and wise thoughts, Margaret. Thank you very much. There is a question to Justice Arjun Sikri. Justice Sikri, one of the students of Jindal Global Law School, Dishant Chowdhury, is asking about, he refers to Professor Upendra Baksi's article on law and state-regulated capitalism in India, and he has said that how excessive, do you think excessive legalization and judicialization of labor laws in India has led to somewhat de-radicalization of the working class consciousness, which in turn ended up, let's say, undermining the rights and their social status? In some ways, he's questioning about the inevitability of judicial intervention that has somewhat affected the ability of the working class to assert their rights more effectively. Justice Sikri, you heard that question?
Sorry, this question was addressed to whom?
To you.
No, can you say, because I lost the voice, I was not able to hear.
Oh, I'm so sorry. So there is a question by Dishant Chowdhury, who is a law student at Jindal Global Law School. His question is in relation to state-regulated capitalism in India, which is an article written by Upendra Baksi, and he says that, do you think excessive legalization and judicialization of labor laws in India has led to somewhat de-radicalization of working class consciousness so that they are not able to assert their rights more effectively?
You see, this is a very interesting question, although it is not in this context what is being said. Because it may take long time to answer this question, but I'll try to be as concise as possible. If you know our labor laws right from because the Industrial Dispute Act was enacted in 1947. That means I think it is immediately after our independence, or maybe 1 or 2 months before we got the independence. I don't remember the exact month. So August 47, India got the independence. If of that vintage, and thereafter series of labor laws were passed, which have been giving rights to the workers of so many nature, so many aspects. Look, we have Payment of Wages Act, so Minimum Wages Act are ensured, wages should be given on time. We have Payment of Bonus Act, minimum bonus is assured. We have Gratuity Act, where gratuity is assured. And under the Industrial Dispute Act also, it is the principle of hire and fire is totally abolished there. You cannot, once you hire, but she should be a workman, and the workman is defined in Section 2S of the Act. Which means that a person should not be holding managerial position. They are governed by the contract, law, that is whatever is the contract provision between the parties. But other workers are protected insofar as the employment, etc., is concerned, and all these acts. But what has been happening, if you see the history of the implementation of these laws by the Supreme Court from time to time. And it's a very interesting, maybe to the our panelists from other countries as well, that in the beginning in 50s and 60s, it was normally a balanced approach. Whether you can't say that it is the judgments are pro management or judgments are pro worker. But then this socialist period came, and we had judges like Justice Krishna, Justice Chinnappa Reddy, etc., and Justice D.A. Desai. And during that period, going by the spirit of socialism, most of these laws were interpreted in favor of workers wherever they could have, it could have happened. And so many, all these provisions are interpreted, but in interpreting the provisions heavily loaded in favor of workers, so many rights were created. But then what happens when the third era came, that is what we call liberalization or globalization from 1992 onward, then the Supreme Court also started backtracking insofar as giving of those rights to the concern. And Professor Bakshi has written that article in that context, whether in the global, because I have also read that article, that in the era of globalization, now whether we are taking away the rights of the workers, now we are totally going whole hog in the other. So from the approach, which is the middle approach, to the leftist approach, now to the totally rightist approach, which the Supreme Court, and there are various judgments to that effect. And I tell you, when because the person, that student from your Jindal Law School who has asked the question, I don't know, may know, may not be knowing, that there was a time in 1970s when a particular it was either legislation or some provisions were passed, the workers' participation in management. So it has gone to that extent that the workers should be allowed to participate in the management, and they have to be taken in the management boards, etc. But today the position is totally different. And in recent times, the new government has, which they have brought the labor code. And if it is implemented, it is said that it is, I mean, one of the perception is that it is anti-labor in the sense that it is loaded in favor of the employer. So all these things are taking place from time to time, and it is a matter of great debate as to what should be the correct law, and how should be the law that the rights of both the workers also and employers also are balanced.
Thank you so much, Justice Sikri. There is a range of questions which are focusing on the balancing between fundamental rights and civil liberties on the one hand, and emergency measures imposed by the pandemic. And I will throw that question to all three other Justice, Michael Wilson and Justice Emmanuel and Justice Sabrina. Along with it, particularly Justice Sabrina, along with this question of balancing, what ought to be the new test when it comes to these, civil liberty, let's say, restrictions. I would also like you to reflect on a question asked by Subramanian, who's asking about to what extent the force majeure clause was going to become relevant, very widely relevant in today's context, because I think it is only fair to say that contracts across the world are going to be, let's say, force majeure will be invoked for non-fulfillment of contracts. Now that in itself will have huge implications for many workers and jobs and things like that. So how do courts need to or will respond to that, in addition to the other two questions? So let me start with Sabrina and then Emmanuel and Mike.
Thank you. Great questions. First, with respect to the test, I think that it is always in a pandemic situation, governments do have the power to regulate for purposes of safety and health. However, any regulations must be reasonable and cannot go further than is necessary to protect health. We have to remember that. The United States has a striking example of that, not a pandemic, but war. Japanese Americans in the United States were incarcerated during World War II just because they looked like the enemy. We cannot allow those types of things to happen again. With respect to force majeure, that's a very interesting question. I actually helped a a contract drafting class, a Zoom class at the University of Hawaii Law School last night, and I talked about force majeure clauses and how we in the judiciary are going to be interpreting force majeure clauses. And would you wish, and I told the young lawyers how important it is for young lawyers to understand what's happening in the world and try to envision what might happen. Because I would love to have had a lawyer, if I was a client, that wrote a force majeure clause that protected me from a pandemic situation. And, you know, I mean, if there's been enough happening, there's been a lot of discussions about pandemics. So we're going to have to interpret the clauses as they come up. The last time I had to do it was when I was a trial judge after the Lehman Brothers, after 2007, 2008. We had terrible situations happening in Waikiki with some of the tenants and things. And the issue was whether or not this was unanticipated, whether the force majeure clauses would apply to relieve the tenants in some of those situations. So we're going to have to look at the language that was drafted and interpret it.
Thank you so much, Sabrina. Emmanuel.
Thank you very much once again, Professor Kumar. We all do agree that humanity is facing a global crisis. And many people will agree that the measures, by and large, taken at least in this part of the region, are to an extent justified to fight the COVID-19. However, to an extent, some governments can take advantage of such tragedies and crises to clamp down on very important constitutional rights. Some rights, such as the right to privacy, which my colleagues have spoke about, are significantly curtailed. Use of excessive force against persons has been witnessed in all the 6 partner states of this country. Discrimination in affording medical care may also take place. The decisions that people and governments take during this pandemic will probably shape countries and the world for many years to come. We should therefore take into consideration the long-term consequences of our actions. When faced with choices of alternatives, we should always ask ourselves not only how to overcome the immediate threat, but also what kind of world we will inhabit after the pandemic is gone. The question is, will we inhabit a different world? It is therefore important now to answer your question that in order to safeguard human rights, governments should be more transparent in the way they inform their citizens and residents of the COVID pandemic. Information and transparency are key. People should be informed of the kind of measures taken to flatten the curve and why such measures are taken, and that the measures taken are temporary. The measures taken should not be disproportionate to those required to flatten the curve. Proportionality should be the main principle in scrutinizing actions adopted by authorities which restrict human rights. I think I do agree with also Justice McKenna that the measures taken should be reasonable and proportional to dealing with this question of COVID-19.
Yeah, this is a test adopted in India. Yes,
that's correct. Yes, well, you know, that's a very good example of that's a beautiful example of comparative constitutional law and the law of the principles of law coming together in a converging manner. Mike, you want to quickly respond to the same question?
Yes, the idea of proportionality that has been alluded to by Justice Aguirre Shibuya and by Justice McKenna is a useful concept. We're testing it now with a new emergence, which theoretically, from a proportionality point of view, has condoned a very, very strong exercise of government power because it was proportional. Imagine, if you will, what the Secretary General of the United Nations said approximately 10 days ago when he said the emergency that humanity is facing from the pandemic, and we've discussed well, I think, the kind of proportional reaction of governments and judges in taking unusual action such as releasing inmates, or such as at times shutting down the economy. In Hawaii, our governor shut down the economy so that essentially planes no longer are flying to Hawaii. Now, shift to the concept of a more serious emergency that society will be facing, far more serious than the pandemic, and that is climate change. And it is upon us already. Of course, India, of course, has to consider this in a very striking way, because within 40 years, it may be 160 million people leave Bangladesh because of sea level rise. So the Secretary General has rightfully brought up how this might prepare us. But when you think of the emergency measures and the proportional measures that are likely to be employed necessarily in order to keep the Earth from heating, in order for global warming to be taking place, you could see that there is a straightforward likelihood that the action taken by government, including the judicial branch, will be less extreme when we have to confront climate change than it is with respect to the pandemic. So this is a good exercise, I think, for judges in particular, for trying to deal with a very unique emergency, because it, you might say, is the greatest emergency contemporary human society has faced, preparing us for one that's likely to be even greater.
Thank you, Mike. Margaret, there are a number of questions that have been focusing on the vulnerability issues surrounding COVID-19, particularly within homes as well, which are focusing on to what extent the justice delivery system should respond. We have questions from Nishit Thakkar, Ankit Kumar, Yashvi Goyal, Aditya Jobi, Khadija Fatma, Pavan Kumar, Naveen. One of the things they are raising is that, COVID-19 has created a situation where, particularly in countries where people are at home, to what extent new forms of vulnerability, including domestic violence, child abuse, that type of vulnerability has come into the forefront. And in the zeal and enthusiasm of justice delivery mechanisms to focus on the larger issues that they are, really spending their time, do you think issues relating to women, but also children and other groups get ignored? And how should, courts should have a better system to respond to this?
That was one of the concerns that arose very early when the government was deciding upon what measures, and particularly people being required essentially to be much more in their home than they otherwise would be. In some ways, I see this as a societal problem more than a legal problem in one way, because the experience here in Australia, particularly in relation to domestic violence and child abuse within domestic violence situations, is that women will be more inclined, if I can just use a very neutral word, to leave the place where they are vulnerable if they know that there is provision for them somewhere else, and by way of shelters and refuges and alternative accommodation and the like. That's our very strong experience. A number of the organisations that I've spoken with over the last couple of weeks who deal in that area have been indicating that, for a start, they thought that the inquiries in relation to alternative accommodation and the like would have been more, hasn't eventuated to the extent that they otherwise would have expected. They think that's because there is a real concern that to go from a place of domestic violence into a place where they are provided with security, it's more often than not a joint home or joint accommodation. So they're going from a situation which is known to them into a situation, although bad though it might be, into a situation where they may be at risk in terms of health. So there has been an increase, I'm told, in the number of inquiries. In the first couple of weeks, there was an increase in the number of inquiries which were, where can I go? This really turns bad on me. But then as the weeks went on, there was not such an increase, but an increase of about 10% or so of those sorts of inquiries. So I see it very much as a social problem, because the courts are not going to deal with these problems unless a case for a sort of a domestic violence prevention order is made. And I just really haven't had much of a feedback that those applications have increased. But in circumstances where our courts are still operating, then I can only assume that those lists are still running.
Thank you. Thank you so much, Margaret.
There's a societal question involved, and it really is the availability of alternative accommodation. And that's when women will leave home. If they've got nowhere to go, it becomes extraordinarily difficult for them.
Clearly, the COVID-19 crisis exacerbates the pre-existing vulnerabilities in society, and that is an example of it. Justice Secretary, there's a question from Nagendra Gupta of OP Jindal Global University, specifically for you. He's raising a question about, how even our courts are reluctant when it comes to intervening on behalf of, let's say, payment of wages to migrant workers in relation to COVID-19 lockdown. And courts are reluctant, citing issues of whether they should intervene on policy matters. Of course, you and I know that Indian Supreme Court in particular has historically not shied away from intervening on policy issues, particularly when issues of fundamental rights are in question. So, but however, COVID-19 has created a very unique scenario where there is a feeling among many, and that's what is reflected in Nagendra's question, that even our courts are timid and somewhat reluctant to intervene on these matters.
You see, I think the concern which he is expressing is justified, but I would say it's a very peculiar situation both ways. As I said, look, I remember one of my friends who is a exporter, and he was telling me a few days ago when we talked to each other on phone, he has since he's an exporter of garments, etc., so most of the orders from overseas he gets, which are manufactured, and fabrication happens here, and these orders are exported. So he was saying that, look, because of COVID, either all these orders are getting, most of the orders are getting cancelled or postponed. They are saying that don't send the for now, stop as far as shipment is concerned. Now he says that on the one hand, we have no income. I have 4,000 to 5,000 employees. I have given the wages for the month of March without work. But for how long I should keep on giving the wages for April, etc., when I have no income at all? Now, so therefore, I was saying this COVID has created a very peculiar situation. It's not that the employer is earning and doesn't want to pay to the workers. And on the other hand, we have also the principle of no work, no pay. So they are trying to use this principle, saying that, look, maybe it is because of, again, force measure that the government has asked us to stop, that we are not able to carry on that activity. Workers are not working, why we should pay? That is one side. And on the other side, yes, from humanitarian angle and others, and even under the Payment of Wages Act, if the situation is created by force majeure, it is equally the right of the employee or the worker to say, look, I am ready to work. I am not made to work because of the order of the government. So therefore, I should not be deprived of my wages, which is again a legitimate argument on behalf of the workers. But yes, at the same time, what I would see is these may be the arguments on both sides. But I agree with the person who has asked the question that at least the court should decide these. These are the issues which are of paramount importance, which should be decided immediately. And the court should not, because if the wages are to be given, the worker who is hand to mouth. And in India, we know that these workers don't have savings. That if that they are not able to work, they can draw on those savings and can sustain for months together. That is not a situation. These poor person, and particularly, as I said, the daily wages, etc. Also, they depend upon each day's wages or each month's wages. If they are not given a wage for 1 month, then it is going to create those situations. So therefore, court, whatever view is taken, and once in labor jurisprudence, if two views are possible, then the one which favors the worker has to be taken. That is also a law. Maybe management or the employers are put under some financial strain. They may be able to recover when the things go normal, but the loss which would be to the worker at this stage, when it is a question of their life, in the sense in the family, it becomes a matter under Article 21 in that sense. So therefore, I agree with him. The court should decide whatever decision is to be taken. These should not be procrastinated.
Thank you so much, Justice Secretary. Well, we have been getting literally hundreds of questions. All good things need to come to an end as well. So it's the first time I'm doing one of these sort of moderating a global judicial colloquium. I'm really grateful to all the judges. So as we
But you have done good job. You have done excellent job.
I have two closing questions to each one of you, and that's our closing question. The first question is, a large number of people are watching include students of law. They're watching this program. I would like each one of you to reflect about, what should the students be thinking about their future? How should they be thinking about their future careers in law and justice? And how do you think they should deal with uncertainty? That's the first question. And the second question is, this, of course, has created, as all of us in the course of this discussion have noticed, that enormous strain on the legal system. It has created expectations on the justice delivery mechanism. So I would appreciate if you can briefly reflect on a couple of reforms that judiciaries around the world need to undertake as we slowly but hopefully move into a post-COVID world. One, your message to the law students and potential students of law who are watching the program about the future of law and justice. And second, what are the reforms that you think judicial systems need to create as you look at the future? Let me begin with Justice Michael Wilson.
Well, looking into the future these days is a very difficult proposition compared to what it was about a month and a half ago. But from the point of view of somebody that's a young law student, considering how to deal with the future and deal with the law, if you will, I would suggest that it's very important to do some self-reflection about what you are about, why you wanted to become a lawyer. And once you determine that, say, for example, you want to do work that has to do with human rights, or if you have an interest in doing work that's more focused on the financial markets, then it's time to start developing as much of an expertise as you can by identifying leaders who are going to be able to help carry you along, because it will be a turbulent time with lots of change. The great opportunity to do that is presented in India. This is where I'm sure much of the audience is from, with a tradition that is the tradition that might be the most important one in creating human rights in the entire world, whether you're talking about Ashoka, or you're talking about Mahatma Gandhi, or you're talking about the brave forefathers of your Constitution that have instituted the Constitution and a Supreme Court that's been willing to be a noble one. So you have people like Justice Decree, and then you have leaders who represent a tradition. This is a tradition to some extent we have in the United States, partly because of India, but it's a tradition of leadership, a leadership in terms of standing up for what is right. The legal profession is not profession that is the same as most. It has a social conscience. It has an aspect to it of, if you will, a requirement to seek justice. It's actually in the United States something that is a formal requirement of attorneys to engage in pro bono work and represent the disadvantaged. So from that point of view, get ready. Understand who you are, because there are going to be, and there already are, a lot more disadvantaged people, and there are extraordinarily intelligent, capable entrepreneurs that have made a tremendous amount of, have achieved a lot of financial success. So if you're going to be continuing in the role of a lawyer, it's a very exciting time, but I would say connect your star to those who you can look up to and you respect. Understand who you are and try to stick to the truth as much as you can. That will help ease a lot of stress as time goes on. Truth with respect to telling your clients the truth, even if it's difficult. Truth with respect to representing the society, where sometimes it takes courage. India seems to have more courage, a history of more courage, of standing up against the odds. And I know the rest of the world looks forward to the young people who are already very formidable and very brave and committed to trying to keep the rule of law moving in the direction, as they say, in a direction that would mean that moving towards the arc of justice.
Thank you, Mike. Justice Emmanuel Ugar-Shibija.
Yes, thank you. I would advise the students who are listening to us that they should go back to the traditionals of what makes law what it is and the practice of law. And that's, I stress on the issue of integrity. Integrity is key to what the students do. Yes, it has always been there, but I think students should take into consideration that. But further from that, I believe that students should learn to form opinions which are based in facts or beliefs, which may be accepted as facts, especially in this era of social media, which tends to erode thinking. I do think that critical thinking is a skill which should be imparted to law students now more than ever, with a view of ensuring that students are able to understand the logical connection between ideas, identify, construct, and evaluate arguments, detect inconsistencies and common mistakes in reasoning, because now we can see that going further. But I want to draw an attention to our listeners to the World Economic Forum report in 2016, and it talked about 10 skills that will be required to thrive in the fourth industrial revolution. And the first one is complex problem solving. The second is critical thinking, creativity. The fourth is people management. The fifth is coordinating with others. The sixth is emotional intelligence. The seventh is judgment and decision making. The eighth is service orientation. The ninth is negotiation. And then the 10th is cognitive flexibility. So these are skills which have been identified by experts. And the experts say that it doesn't matter which area you are in, whether you are a law student or aspiring to be in the legal profession. These are the 10 skills which sometimes are not taught in the law school, which students need to acquire in order to succeed in the fourth industrial revolution. Thank you.
Thank you so much. That was fantastic, Emmanuel. Those skills, I'm sure, will be immensely beneficial for the students and others who are watching. Sabrina, I would like you to reflect as we end this program.
Okay, aloha to all of the law students. I feel for you. My oldest child is a law student. It's really different going through law school remotely. But let me just assure you that this is going to pass. This is going to pass. The economy is going to be hard hit for a while, but legal practice changes with the economy. I've been through many depressions, ups and downs in the economy, and there is always work. It might be a different kind of work, but there is work that needs to be done. And there's going to be very important work that needs to be done. So this is a time for cognitive flexibility. Think about what the work might be in the future. And you are a generation that understands and uses technology much more than us. Think about how you might be able to develop your practices, how you might be able to change the practice of law using the technology that you have now. But the most important thing, and something I tell my children, right now, stay healthy. You may think you're young, you may think you're not going to get hit by this. You don't know what the long-term effects of this might be. So stay healthy, protect yourself. That is so important. And addressing your second question with respect to the courts, I think the courts need to do the same thing that I've been telling the law students. We need to adjust and use the technology and the intelligence that is available now, and to develop courts that meet the needs of the future. Thanks a lot.
Thank you, Sabrina. Margaret.
Very difficult to add to some extraordinarily insightful comments which have been made. So rather than seek to repeat, let me go through it in a slightly different way. Given that my role these days is as governor, which is not an elected governor, but is an appointed governor in a viceregal sense. And so my concern is very much with the community. And I think law has always been a hard and a challenging profession. And it's a profession which we should always ensure that it's not only available to an elite. In fact, it's a great thing that we have universities around the world, and Jindal is one, which doesn't only play to the elite, which one usually means money, but enables amazing education to take place. And education is something to be used. It's for used for yourself. You are entitled when you graduate to reap the rewards of being a highly skilled, highly professional person. You're absolutely entitled to enjoy every moment of that. But what the law does for you and should do for you, having regard to all those qualities that are needed, particularly the analytical qualities, the cognitive ability to connect problems, work through problems, it gives you a unique place in the world in leadership. And there has to be, I think, a part in your roles in the future where, with all the challenges it will bring personally, with all the uncertainties it will have for you in jobs, working through that is going to give you a place of understanding people. I always say to young students, there is no legal issue which doesn't have a person behind it. Doesn't matter whether it's an insolvency issue, doesn't matter whether it's all about rocket design. Somewhere along the line, there are people behind that. And I think that's one thing that is very good, a very important thing for you to remember when you are working through your problems. You are working through your problems to assist others. And that in itself is an extraordinary community service. Every time you do your job extraordinarily well, you've actually engaged in the community service, because when you do your job well, do it in accordance with what this seminar and webinar is intended to be all about, the way the rule of law actually operates in society.
Thank you very much, Margaret. Justice Sikri, you are having the last word on this.
Yeah, thank you, Rajkumar. What I feel is that, and particularly the students, most of maybe from your school and other law schools also, but from India, as Justice Wilson also mentioned. If you remember, Rajkumar, about maybe 10 days ago or 2 weeks ago, we had of Campus Law Center one webinar almost that was entirely devoted to this particular theme as to what is going to be the future of the students who are the budding lawyers and going to enter the profession. And maybe what I feel is that many students in India are becoming susceptible to about this idea that, look, as far as legal profession is concerned, it may take a hit, that there may be, because of technology, etc., and maybe when artificial intelligence also comes, there may be lesser work, so whether they should join the profession or not. So these are some of the apprehensions in the minds of the students. So what the particular attributes or the new types of techniques or qualifications which they should acquire is very eloquently said by all other speakers, which I would not repeat, and I would only say I agree. But what I'm trying to say is that number one, we can see it from two aspects as far as newcomers are concerned. Number one, when we talk of legal profession or those who do law and thereafter they are finding some foothold in a legal profession, it is not necessarily the legal practice in the courts. That is only one facet of the legal profession. We have in-house counsel, we have the counsel who are the human rights activists, etc. Then because in-house counsel are also the counsel who today there is a great demand, and they also acquire good status in the society. And we have many companies and many multinational, starting from even small scale to medium scale to multinational corporations, where the in-house counsel have their today value. So then we have the profession that Rajkumar belongs to, that the good teachers we want in law. So therefore, the students can aspire to become good teachers also. So there, first of all, you have to keep in mind what is that you want to become and where you want to go, and then you have to acquire the attributes of that particular field. Now, coming to specifically legal profession, that is practice in law. And I have forgotten one thing, that corporate practice is also there. Not only litigation, corporate practice is also there. So there are so many aspects which are, or so many avenues which are open. Now, coming to, let us presume that the question is aimed at litigation practice and practice in the courts. Now, we were talking and we have talked, and that is the second question also, which Professor Rajkumar put, was about the reforms in the judicial process, judicial reforms, etc., use of more technology, which is talked about. If that happens, according to me, new generation is not the loser, they would be the gainer. Reason simple is that they are much more techno savvy than we people. And so therefore the advocates of who are mature in their age, etc., would need the services of the young lawyers more, not only because of their wisdom or their competence in law, but in technology also, because without that they will not be able to function. So that is one side of it. So therefore your demand would be there. Now even if this technology is introduced, and let us say it comes, it is not that, as Justice Sabrina rightly mentioned, this shall pass. It is not that we are going to have COVID situation for all times to come, and therefore we will come back to the it takes 2 months, 4 months, 6 months, 1 year, we don't know, because as of today we don't have any answers. But we know that when the normalcy comes back, we will see all that hustle bustle in the courts. The people would be there appearing in the courts, and in India the same scenario we would witness. Another thing, insofar as legal profession is concerned, let me tell you, and that is, we can see it from historical facts also, that we have been seeing it, that such situations, difficult situations, even if we talk of recession, they create rather more work for lawyers. That is one thing which has to be kept in mind. When there was recession in 2008, worldwide recession, though the lawyers who were practicing on insolvency laws got much work because of that. Now, COVID is because of force majeure, which we discussed, and other issues we discussed, it is going to generate much more litigation post-COVID. So therefore, there is a future is bright for young students. You have to acquire all those skills which my other speakers told, and you have to be honest to the profession when you come, and it is ultimately the honesty and hard work which pays. With that, I say my good wishes to all the students who are listening.
Well, thank you very much for an extraordinarily wonderful set of distinguished jurists representing different jurisdictions from around the world. I'm grateful to Justice Sabrina McKenna, Justice Margaret Beasley, Justice Michael Wilson, Justice Emmanuel Ogrishabuja, and Justice Arjun Sikri for your time. We just started this global colloquium webinars today. We couldn't have had a better inaugural session with the kind of extraordinary perspectives that all of you have provided. Being a lawyer and a law professor, I would have not had any other topic but rule of law and access to justice in the age of uncertainty as the first theme. And every Saturday, we will do a global webinar. And I will, for all those viewers who have had watched this, we've had over 1,500 plus registrations around the world, and over 500 people continuously attended it. We've got over 300 questions, and I'm sorry that I couldn't take all the questions that have come through this. But all I can say is that the kind of perspectives that the judges have generated today has provided enormous hope and optimism for the future. It has also created an awareness about the importance of protecting the rule of law and promoting access to justice, even in the age of uncertainty. In fact, during these difficult times, the role of institutions that are vested with the task of ensuring justice becomes even more important. So with those words, I would like to once again thank all our distinguished judges across the world who are being part of today's webinar. I'm sorry that we overshot time so much, more than half an hour, but I'm sure all those who viewed this are, have been benefited. We will come back again on next Saturday with a global lawyers colloquium on the theme global lawyering and the corporate legal profession in a post-corona world. We will have Mr. Nishit Desai, the founder of Nishit Desai Associates, Mr. Haigreev Khaitan, the founder and managing partner of Khaitan and Company, Mr. Nandan Nelivigi, partner of a major US law firm called White & Case in New York, Mr. Chris Parsons, who is a partner of a major UK law firm called Herbert Smith, and for also Mr. Cyril Schroff, who is the founder and managing partner of Cyril Amarchand and Mangal Das. We will meet again on Saturday, the 9th of May. Till then, I would like to thank all of you for your patience and indeed participation in this first series of global webinars hosted by OP Jindal Global University as an open access public interest initiative. Thank you very much.
Thank you.
Thank you.
Thank you. Thank you, everyone.
Thank you. Thank you.